Welcome to AIH Connected, our online patient conference. My name is Erin Anderson, and I'm the Director of Programs and Advancement for the Autoimmune Hepatitis Association. I'm excited to introduce our next speaker, Keith Butler, Senior Attorney from Indiana Disability Rights. Parents of children with autoimmune hepatitis often wonder if their child can qualify for extra support in school because of their disease. Keith is here today to share more about what can be possible under current laws. Welcome, Keith.
So hello, my name is Keith Butler. I am with Indiana Disability Rights. And I just wanted, before I shared my screen, get at least a chance to see me in person. So I'm going to go ahead and share now and get into the actual presentation. So like I said, my name is Keith Butler. We're going to talk about disability rights in school and in the workplace in this presentation. It's going to be pretty high level, just because these are kind of like the big areas. One of just, for example, one of the three sections is what I basically concentrate most of my practice in. And that's just one of the three sections. So obviously it's a fairly high level, but hopefully it's going to be fairly practical and useful to what your needs are. So I am a senior attorney at Indiana Disability Rights. I've worked at IDR since 2010. I am over the education and employment teams. I do mostly education cases. There's another attorney in our office that does most of the employment, but I'm the kind of like the attorney over both teams. So I'm going to start out by just kind of talking a little bit about Indiana Disability Rights, and then get into the more, I guess, direct subject area. So we've got school, meaning like kindergarten through high school, college age students, and what some of the laws are with that, and then a few different areas in employment law. And I tried to, tailor this to autoimmune hepatitis. So we'll try and cover how that might apply to these areas. So there's this YouTube video here. Here's a link. I think we might try and send this out with materials separate, but it's a pretty good video to watch. I'm going to blame this completely on my lack of technological skills. It's a little hard to get it to work to play this through Zoom, but this is like a 2-minute video that explains what the protection and advocacy system is. So there's a P&A or protection advocacy group in each of the states that are designed to protect the rights of people with disabilities. So this is IDR, Indiana Disability Rights mission, to protect and promote the rights of individuals with disabilities through empowerment and advocacy. And this is our vision. I won't read it to you, but basically, like I said, there's one of us in every state. I know that this presentation kind of goes out beyond just Indiana. And so if you're a person with a disability or a family member of the person with a disability, and there's some sort of like legal question or right you think that is rights violation on legal grounds that you see, there's a pretty good chance that either the Indiana organization or whatever state you're in can handle those areas. We're originally started doing abuse and neglect cases a lot of times in residential facilities where there isn't great access to the public to kind of see what's going on in there. And so our organizations have like legal access to get into these areas and monitor and just look for abuse and neglect. But obviously we've branched out beyond that, as today we're talking about mostly education and employment issues. So that's just a little bit about what our organization is and what we do. So as you're going through this, if you have questions about this presentation, feel free to call me directly. That's my direct line. It's actually a cell phone number, so pretty easy to get a hold of me. That's my email address. If watching this presentation, you think, hey, I might have a case that IDR should take, I would encourage you to call the the number below, so you can send an email, you can call the 800 number, or there's even an online form to fill out. You know, it's just easier that way, even if it's an education or employment issue, because the intake people know how to fill out the right forms and get the right information to open up a case. And I would probably mess that up if the call goes directly to me. So if there is like a new case, I encourage you to call intake, but questions about the presentation, feel free to contact me. So all that aside, getting into the actual presentation here. So the kindergarten through high school, there are two main areas of disability or like special education law. One is the Individuals with Disabilities Education Act, or IDEA, and then I have to the right of that in the slide Article 7. Again, this what Article 7 is, and this kind of only means something to Indiana, is so IDEA is a federal law, right? Then and the way it's set up is it provides funding to states to do special education services if they meet certain requirements. And then the states have to actually enact regulations that kind of match up to the federal law so they can get funding. So Article 7 just means that's the regulations in Indiana that comply with the IDEA. So if you say Article 7 outside of Indiana, no one's going to know what you're talking about, but there's a similar set of regulations for every state where they enact regulations to comply with the IDEA. And then there's also what's called Section 504 of the Rehabilitation Act. You might hear something like somebody has a 504 plan. So that's what that means. It refers to that part of this act. Generally, if you could qualify for both, or a student could qualify for both, most people prefer to be eligible under IDEA. And I'm going to get into more of the reasons for that later. It's not so much that 504 can't do the same things that IDEA. It's just that the IDEA law is just much more specific. It's just more spelled out. So this slide just kind of goes through some of the differences. Like I said, so the overall goal of IDEA is what's called free, appropriate public education. And I'm sure, like a lot of other areas in life, everything in special ed law gets reduced to acronyms. So, people in the area would just refer to that as FAPE. And then the overall goal of 504 is equal access for people with disabilities to programs receiving federal assistance. Obviously, most schools receive some sort of federal assistance. So the person with disabilities would have, the goal is for them to have access to special ed services. Or excuse me, access to education, like people without disabilities, and then the special ed services are designed to give them that access. As I kind of touched on before, IDEA has a lot of very specific statutes and regulations. 504, there's not as many. I mean, there are some, but there's just much more general. And so a lot of times you have to look at documents that the Federal Department of Ed will put out, or even like court cases, to kind of get what the actual specifics are. So that's another advantage to IDEA. And then finally, eligibility, and this is probably one of the main reasons why you might have a 504 as opposed to an IEP. And we'll talk about what IEP means, but an IEP under the IDEA is that you have to be eligible under a certain category to qualify for IDEA. And I think there's 13 categories. So we'll kind of get into what those categories are later, but the only requirement under 504 is that you have an impairment which substantially limits one or more major life activities. Education is considered a major life activity, so if you have any sort of disability that affects education, then you would qualify for a 504 plan. It's just a question of whether that plan is necessary to give the person access to educational services, or if it isn't. So I'm going to kind of go through more IDEA specific the rest of the presentation, but as I kind of touched on, a lot of these concepts you can find in 504, they're just not as spelled out. So I try to create some bullet points here. They're the main concepts of IDEA. As I talk about free appropriate public education, or FAPE, the concept of least restrictive environment, and we'll get into that, the individualized education program, or IEP, and then the rights to have an evaluation, and we'll talk about some procedural safeguards. I guess before I get into this, I didn't create a separate slide for FAPE, or free appropriate public education. And kind of the reason for that is, I think in large part, whether you get FAPE or not is defined on whether the school is meeting all of their requirements in the rest of the section. Are they doing evaluations? Do they have like an IEP with goals and all the sort of things we'll talk about? But there was a recent Supreme Court case called Undue F that did say that schools, like beyond just sort of like following all these regulations, they do have a substantive duty to provide education beyond just like, even if they sort of like meet all these goals, but the student isn't really advancing, that's not good enough. And so the actual language in this Undue F Supreme Court case is reasonably calculated to enable a child to make progress appropriate in light of the child's circumstances. So that's the sort of like the best definition of what FAPE means beyond meeting all the technical requirements that we're going to talk about in the rest of the presentation. So least restrictive environment, this is a pretty big issue in disability rights in general, and again, it's part of this area. And as the slide says, the maximum extent appropriate, students with disabilities are educated with non-disabled students. Now, part of that means if a student needs more, and where the word appropriate comes in, then the school is required to provide a continuum of services. So sometimes that might mean that a student is mostly in gen ed and has just some kind of like extra help, or they might be mostly in gen ed and spend time with a resource teacher. There's maybe they need a separate classroom. Again, the preference is not, but maybe like a life skills class. Again, if you can do this appropriately without doing that, then that's the preference. But that service needs to be available, and then these services go all the way down to all-day program or residential services, kind of like a way on the other end of the continuum of services. So that's least restrictive environment. So an IEP, that the acronym actually stands for Individualized Education Plan up there. I just caught that. It's actually Individualized Education Program is the technical term for that. So these are kind of some of the components. The case conference committee is just the team that meets to decide what the IEP is. It's going to include, if the student's under 18, the parents, and then certain required people from the school. So generally a school administrator or somebody that can commit resources from the school is how it's defined in the statute. What's known as a teacher of record, which is generally just the special education teacher, and then just other kind of people that are, well, a lot of times if the student's getting speech services, the SLP or the speech person will be there. So just there's going to be like required school people, and then that team is supposed to come together and decide on what the IEP is going to look like. So parts of this document will be the students' present levels. There have to be measurable goals that are followed, and sort of educational services, related services, supplementary aids and services. This could be anything from extra time on test to a like I said, time in a resource room where you get extra help with your math, to help with disability, as far as somebody needed help using the restroom. That could be a related service. Supplementing aids and services could, you have like a vision or hearing issue, like you need large print documents, stuff like that. All those could be somewhere on this sort of like level of services. But the idea is these are things that are necessary for the student to get free, appropriate public education. Evaluations are an important part. The first time you get an evaluation, obviously the goal is to determine whether the student is eligible, but part of evaluations are also to make sure that the services are appropriate. So that's part of ongoing evaluations. There is a right to do a reevaluation every 3 years unless parents agree it's not necessary. And parents, and I'm using parents, which could obviously different, could be guardian, could be the student if they're over 18, but I'm just kind of using the parent as a general term. They can request what's called an independent education evaluation if they disagree with the school evaluation. There's some reasons why the school can reject that. They're probably beyond the scope of this training, but in large part, if a parent disagrees with the school evaluation, they can get an outside person to do an evaluation, for the case conference team to consider along with the school's evaluation. So there's procedural safeguards built into the regulations. One of which being is the school is required to give you a document that lists out what the safeguards are and kind of what your rights are. In Indiana, you can go to the Indiana Department of Education website and download what kind of like the model of what schools are supposed to hand out for this, which is actually a pretty handy document in understanding special ed law. And I'm guessing that's probably true in most states as well. Along with that, they have to give you notice. So if there's going to be a case conference, they have to notify the parents and try and coordinate with them and when the case conference is going to be. You can't make a change to the IEP without giving notice, that sort of thing. Informed consent. Shouldn't have a parent sign something that they don't understand. So it has to be communicated in a way that they can. And these last three are legal rights to, if you don't agree with the IEP. So one is mediation, and so a trained mediator that's not part of the school system will try and mediate an agreement between the two parties. You can file a complaint with the state Department of Ed, and then they'll have an investigator look at it and make findings and decide whether the school violated the rights, and if they did, how to correct that. And then due process is an administrative hearing process. So, kind of like a court case where both sides present evidence, call witnesses, and make their case. And what's called an independent hearing officer, who's basically an administrative law judge, will make a decision. And actually those decisions can be appealed all the way through the regular court process. So I try to kind of, at least in my mind, make this, specific to autoimmune hepatitis. So these are kind of the two questions I would ask myself when you're deciding, like, what, if any, sort of special ed law you might want to take advantage of. And again, like the second question is this purely a medical issue, or does it impact other areas of education? In other words, do you want, plan with academic goals and like actual help with academics, or is this more, hey, I think my student might be missing a lot of school because of doctor's appointments, and I want to make sure they're not, that counts against them, or that I do go down to the school nurse and get medicine, that sort of thing. So I think depending on how you answer those is how I'd recommend looking at what to do next. So I've kind of three categories here. A lot of times you'll hear something in schools called a health plan. I don't think there's anything wrong with having a health plan, but I would just make sure if it's a health plan that it's part of a 504 plan that has like a health plan component to it. And the reason I say that is there's no like health plan law, right? So, and basically if you have a health plan, you're basically asking for an accommodation under 504. So you might as well call it a 504 plan with like a health component, just so it's understood that all the laws and protections of a 504 plan apply. And again, if that's like the only thing you need is, hey, I want to go down to have the student go down to the school nurse and get medicine, you know, after lunch each day, you might not want the IEP where you have all, you know, like the educational goals and you know, things that they're supposed to work on and all these things that just might not be necessary. But if the student has more direct academic needs, like down here, extra time on test, assistive technology, maybe they need occupational therapy or physical therapy, any of those things, then I would at least ask for eligibility under IDEA or ask for an IEP. So I said there's 13 different categories of eligibility. My guess is, and you know, just full disclosure, I have more of like a WebMD type of level of knowledge of AIH than you know, so a lot of people who listen to this probably know a lot more about it than I do. But my guess is the best category to ask for eligibility under is what's called other health impairment. I have it defined down here. But it is one that kind of contemplates if you have some sort of like long-term medical issue. And so on those 2 bullet points at the bottom, the number 2 is really the key to, I think, being found eligible. I mean, I think if you have AIH, you would kind of meet number 1, but you have to be able to show that this the way that the symptoms would adversely affect a student's educational performance. And I think that's the key. Like I said, there are other eligibility categories that might apply. You know, like there's learning disability, there's, I guess, depending on the severity, there's even a cognitive impairment one, but I'm thinking that OHI or other health impairment is probably the best bet to be found eligible. So moving on to college. So the main areas of law are 504 and ADA, or Americans with Disabilities Act. And again, this is technically the same Section 504 that I talked about at the beginning for the K through 12, but I mean, there are some slight differences in that there are regulations that are just for like K through 12, or kindergarten through 12th grade, where there are more college and university falls more into sort of like the general parts of 504. So basically 504 applies to any group, and I think I said this in the earlier section, but that gets federal funding. And I believe that covers the vast majorities of universities or colleges. I think there are a few that don't get federal funding, but I think there's a pretty good bet that they do. And then Title II, and again, this means Title II of the Americans with Disabilities Act, applies to state and local governments, or which would include public universities, and Title III of the ADA applies to private universities, and I'll get into why that matters a little bit later on. But I mean, bottom line is 504 probably applies to both state and private, but either way, at least one section of the ADA would apply to both. Okay, so college 504 plans, you'll in kindergarten through high school, you'll hear it referred to as a 504 plan. And you know, I've heard this, I guess, as background a lot of different times, including people that are kind of in special ed law, is that, oh, one advantage to having a 504 in high school is that it transfers to college. That's not like completely wrong, but it's definitely not right. It's not as simple as that. It's not like there's some 504 repository out somewhere, and then like high school uploads it and the college just like downloads it, and as simple as that, and then you have your 504 plan. There's no like technical transfer of it. So there's not any reason why you would have more or less of a 504 plan in college if you had an IEP or 504 in high school. Really, if you had neither, I mean, they should do their own evaluation. In other words, so some of the it's its own analysis, like what is necessary in college. And I think the high school and the high school IEP or the high school 504 is useful in that figuring that out, but it's not determinative. There's no like rule that says the college has to follow that plan. So here's just kind of a big overview of what 504 means. So it applies to individuals with disabilities that are otherwise qualified for a program or activity that gets federal funding, and they were, and this is what it bars here, that they were excluded from participation or denied the benefits of a program or subject to discrimination based on disability. And again, it applies to programs that receive federal financial assistance. And so we're kind of getting into public universities first here. Here's Title II, and I won't read this all, but if you look at this closely, it's very similar to the 504 definition, other than it says it applies to a public entity, so basically state and local governments. So, and I have kind of 504/Title II at the top, and you will see that in a lot of documents, like they don't even break out whether they're referring to 504 or Title II of the ADA. Specifically, they're just kind of seen as basically the same thing a lot of times, as far as what rights you can get underneath them. So you can't discriminate on the basis of disability. You must allow the individual disability to participate or benefit from the service. And then the third one, you can't have separate benefits or services. So in other words, you couldn't have like people disabilities go in this area, sort of like the old like separate but equal from Brown v. Board of Education. Unless, but there is a sort of like a caveat with disability law, unless doing something separate is necessary for that person with a disability to be able to participate in the activity. So, for example, having a school for the blind wouldn't be a violation of 504 because it's providing a service or a way for blind people to access education. I mean, if you required every blind person to go to the school for the blind, that could be a problem, but just having that service isn't a violation. And this is kind of like the important, just from like legal background standpoint, the most important slide, I think, in understanding this. Again, sorry for like wordy slides here, but this is kind of like the key. So basically, part of the way to define whether someone's been discriminated against or not is whether the entity offers reasonable accommodations or modifications to their program in order to let them participate. So, if you had somebody just maybe like who's like low vision and they requested to sit in the front because that's how they could see the blackboard. To say no, like we have this where we only seat based on alphabetical order and your last name starts with a Z, so sorry, you have to sit in the back and we're not going to let you sit in the front. That would be considered disability discrimination, not because they have any policy that's sort of on its face discriminatory, but because they didn't allow a reasonable modification to let the person access the program or to sit in the front. So the school is required to provide reasonable accommodations unless they would fundamentally alter the nature of the service program or activity. And I mean, as you can imagine, there's been a lot of legal fights on what's a reasonable accommodation, what is a fundamental alteration. Like I said, I think the example of sitting in the front, if you had trouble seeing, it would pretty clearly fall under a reasonable modification that wouldn't fundamentally alter. An example I've heard before that I guess isn't maybe school specific, but let's say a public park had a sand, like beach volleyball pit. Like you wouldn't have to pave that over to make it wheelchair accessible, because that would fundamentally alter the nature of beach volleyball. The idea is that it's on the sand. So, but there's like this whole area of in between as to what is a reasonable modification versus what is a fundamental alteration. Okay, so again, Title III of the ADA is in regards to private universities. Again, a wordy slide here, but it kind of gets the same thing as Title II does, where these private universities, they have a responsibility to allow people with disabilities the full and equal enjoyment of their goods or services. Title III, place of public accommodation, a lot of these are like stores or hotels, restaurants, but colleges and universities do fall under the definition of place of public accommodation. Excuse me. So again, similar to the analysis of Title II, they are required to make reasonable modifications to their policies or procedures, so that kind of like the same examples would apply with the, sitting in the front if you're of low vision versus, something that would fundamentally alter, like paving over the sand volleyball court. I think both of those examples would apply in the same way here. So this eligibility section applies to all three: the Title II, the Title III, and the 504. And there's three ways to be considered eligible. And so one is to have and I believe I've touched on this already, but have a physical or mental impairment which substantially limits one or more major life activities. Again, education is a major life activity, so that makes it, fairly easy. Or you have a record of an impairment, or you're regarded as having an impairment. So in other words, if people let's say everybody, thought that somebody had mental illness, they didn't actually have a mental illness, but they're kind of being discriminated against based on having a mental illness, even though they didn't actually have one, that would still be in violation of this statute based on sort of like the third bullet point. And this, I shouldn't say recently, because it's been maybe 10 plus years ago now, but the way that this is looked at now is that eligibility is supposed to be determined very broadly. And the idea being is you kind of get more into the analysis of whether a reasonable accommodation is actually necessary for somebody to enjoy the goods and services of the activity, rather than does the person actually have a disability. So there's a lot of different ways to meet the criteria. The statute has been changed in a way that specifically says that it's supposed to be a very broad definition. So eligibility is more than likely not going to be the kind of like the main issue in getting one of these plans. So all that is sort of a background into, well, what do modifications in college actually look like? So in general, they're not quite as like all encompassing as an IEP in high school or elementary school. I mean, there's nothing that would specifically prevent that, but it's more sort of like what are some modifications that are necessary in the classroom. So for seating, which we talked about, maybe help with note taking, extra time on tests, ability to miss class for medical appointments, those sort of things. But you're probably not going to get a like social skills goal that you might in in a high school IEP. Like that might be a little bit more challenging, and they're probably not going to include, if somebody's living away from college, they're living away at college and they have a disability, and they have some issue with just kind of some like life skills with living in the dorm. That might be a little bit more challenging to get under a 504 plan. Again, not saying impossible, but they tend to be more just sort of like academic specific. And another difference is, so in the K through 12 realm, that the school has a duty, what's called child find, where they have an ongoing duty to identify students in their area that have disabilities. Colleges don't have that. So if you have a disability and you want a modification, you need to request it. So, if it's going to be an issue going in, then before you start your freshman year, it's probably good to make contact with the disability office and just kind of have a conversation and let them know what your concerns are, and then sort of work that out before you start. Because if you don't call them, more than likely they're not going to call you. Employment. So I'm going to cover two main areas of law that I thought would be the most useful. One is for covering three of the titles of the Americans with Disabilities Act, but Title I is the one that deals with employment, and then FMLA, I thought was just, it's a good one to know just from my, again, sort of like WebMD level of understanding of AIH. I thought this would probably be helpful to go over. Okay, so this is the main part of Title I law. So covered entity, or again, most employers, you have to have over 15 employees to be part of this act. But if it's a employer that's subject to the act, again, I think the main reason I put this in is just if you look at the areas down there, there's a lot. Pretty much every area of employment is covered, from the job application process to the level of benefits you get. So it's pretty broad ranging. It's not just like if you've already have a job and you're denied a promotion. There's pretty much any area of employment is covered in this. So a qualified individual, and with the actual statutory definition, but the key here is can perform essential functions of the job with or without reasonable accommodations. As you can imagine, there's attorneys have probably argued a lot about whether a part of the job is an essential function or not. Because basically, if the employer can say, well, look, this is an essential function of the job, and even with reasonable accommodations, they can't do that part of the job, then they can not hire or terminate the person's employment because they can't do an essential function. But again, it says with or without reasonable accommodations. So what actually is an essential function or not is often the subject of quite a bit of a debate when you get into these actual cases. So reasonable accommodation, again, sorry for the wordiness of the slide, but there are a whole lot of things that could be considered reasonable accommodations. Just thinking about it, like one thing is changing your work schedule, or the ability to miss time to go to appointments could be a reasonable accommodation. So I was thinking that those could be pretty useful things, but there's a lot of different things here that can be considered reasonable accommodations to the workplace. So the employer does not have to do a reasonable accommodation if it would present an undue hardship. And this is how undue hardship is defined. So one thing with the undue hardship definition is it is employer specific. So like, let's say, for example, you have a job as a checkout person. Now, if you work at checkout person at like a big grocery store where there's 20 aisles, and, so let's just say, for example, you can work about 2 hours and then you get exhausted. You need to take like 30 or 40 minutes off as a break, and then you can work another 2 hours, and so on and so forth. If you work for this big grocery store chain that has 20 aisles, I think you could make a pretty good case that that would be a reasonable accommodation to have this 30-minute break every 2 hours, because they've got 20 aisles, lots of different checkout people, and it would not put an undue hardship on them. Now, if you worked for a store where there's only one checkout person at any one time, then that's going to be a harder argument, right? Because when you're not there for that 30 minutes, either somebody else who doesn't normally work in the checkout, but somewhere else in the store is going to have to come and do that, or be unmanned, or just it would. So it's kind of situationally specific, and also the size of the employer. So like a mom and pop shop that just barely has enough employees might have an easier time arguing that it's an undue hardship over, say Walmart. So where we're going to have a bunch of people doing the same job already. So there's that level of that just wouldn't present as big of a hardship. So all those types of things can go into that analysis. And then so FMLA, or Family Medical Leave Act. So it's basically in broad terms, an act that gives you the right to go back to your job after missing some time for an approved situation. Here are the 4 main reasons why FMLA might apply. Obviously, in our context here, the second or the third and the fourth are probably the most relevant: caring for a family member with a serious illness, or the employee themselves having a serious illness. And so you have to have worked with the employer for a certain amount of time to be eligible. And just in my experience, this is followed pretty precisely. So you have to be able to show that you meet both of these, the 12-month requirement and the 1,250 hours in the previous 12-month period. Like their HR department will go back and count that up and make sure that you are eligible under these 2 terms. So these are the main things that you get under FMLA. As I kind of said at the beginning, this idea that you can be gone and then come back. So you have a total of 12 work weeks in a 12-month period. It can be taken intermittently. So if you just don't know when you're going to feel, maybe the easiest example is somebody gets migraines. They don't know when they're going to get a migraine or how bad it's going to be. You can get FMLA for migraine. So all of a sudden you're at work, you have this terrible migraine, you can take time off without getting in trouble for it. So that seems like that would apply in our situation here. It is unpaid, meaning that if the employer wants to pay you for it, there's no rule that says they can't, but they're not obligated to pay you. The employee is required to give 30 days notice when foreseeable. Obviously there are any number of situations why that wouldn't be foreseeable. You're in a car wreck or something, right? You're not going to know that. But if somebody wants to take FMLA because they scheduled a surgery and the surgery's been scheduled for 6 months, and you tell the employer 2 days beforehand that you want to use FMLA for it, that could be a problem. And this next bullet point is important to think about, and that is the employer can require the employee to substitute other types of leave. So like in my situation, I get a certain amount of sick days from my employer. So let's say I had like 10 sick days built up. I couldn't use all my sick days and then say, okay, well, now I'm going to apply for FMLA for my 12 more weeks. Like those 10 days would count against my 12 weeks. So, and again, these are the last are kind of like the protections under this. So you can return to the same or equivalent position after you leave, and you don't lose accrued benefits during the leave. So that is basically the presentation. Here again are the topics we covered, and there's my contact information one more time. And thanks very much for your time. Thank you.